This is video number 4 in our series of educational videos to instruct the people on the science of government and thereby learn how to have government by consent. This video is titled Law and Equity. The judicial power shall extend to all cases in law and equity arising under the Constitution. Article 3, Section 2. Natural law. Samuel Adams said, "The natural liberty of man is to be free from any superior power on earth, and not to be under the will or legislative authority of man, but only to have the law of nature for his rule." Memorandum of Law and Equity. The purpose of this memorandum is to clarify the profound difference between law and equity. Equity courts are nisi prius courts that are presided over by judges who rule according to regulations, statutes, and codes. Courts that proceed according to regulations, statutes, and codes are for government agencies, bureaucrats, and interstate commercial activity, and not for the people. This is extremely important to understand. Statutes. An act of the legislature declaring, commanding, or forbidding something. A particular law enacted and established by the will of the legislative department of government. This word is used to designate the written law, also known as statutes, in contradistinction to the unwritten law, also known as common law. Regulations. The act of regulating a rule or other prescribed for management or government. A regulating principle, a precept, rule of order prescribed by superior or competent authority relating to action of those under its control. Codes. A complete system of positive law, scientifically arranged and promulgated by legislative authority, a systematic body of law. Article 1, Section A, Clause 18. Congress shall have the power to make all laws which shall be necessary and proper for the carrying into execution the foregoing powers listed in clauses 1 through 17, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. Law. Law courts are presided over by juries, 12 people, who rule according to natural law. No judges, regulations, statutes, or codes permitted in a court of law, because they lack due process. Liberty is freedom from equity or civil law courts. In other words, free from government interference of our behavior via a legislative law. Unalienable rights are the spirit of natural law, the law of our Creator and not of man. All law is to be understood in light of our unalienable rights. Any law repugnant to that spirit is by nature's Creator null and void. The law of the land is also known as the Declaration of Independence, the Constitution for the United States of America, and its capstone Bill of Rights. These are all natural law documents that were constructed upon natural law principles. To deny natural law is to deny these documents, and to deny these founding documents would be treason. We, the people, via the Constitution, Bill of Rights, and the Declaration of Independence, vested our judiciary with 2 jurisdictions, law and equity. Again, it is extremely important that we understand the difference between the two. Simply put, the tribunals in an equity court are elected or appointed judges, while the tribunals in law courts are the people themselves, also known as juries. These law courts are called courts of record, that proceed according to the natural law, liberated from statutes. The U.S. Constitution, Article 6, states, "This Constitution and the laws of the United States, which shall be made in pursuant thereof, and all treaties made or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or the laws of any states to the contrary notwithstanding." Equity and justice are substantially equivalent terms, if not synonymous. Under constitutional provision guaranteeing right to obtain justice, the justice to be administered by courts is not an abstract justice as conceived or by the judge, but justice according to law, or, as it is phrased in the Constitution, conformably to the laws. Equity law is the system of jurisprudence administered by the purely secular tribunals. In equity courts, judges are to act under American jurisprudence, which is the philosophy of law, the knowledge of things divine and human, the science of what is right and what is wrong, the constant and perpetual disposition to render every man his due. It has no direct concern with questions of moral or political policy, for they fall under the providence of ethics and legislation. They are to mete out justice, which in the most extensive sense of the word differs little from virtue, for it includes within itself the whole circle of virtues. Justice, being in itself a part of virtue, is confined to the things simply good or evil, and consists in a man's taking such a proportion of them as he ought. Laws of nature is natural law. It is absolute law. The true and proper law of nature, also known as common law, as distinguished from the law created by the enactment of legislators. Common law is the use of legal principles to discover by light of nature or abstract reasoning comprised of the body of those principles and rules of actions relating to the government and security of the persons and properties which derive their authority solely from usage and customs of ancient antiquity. The Supreme Court shall have appellate jurisdiction both as to law and facts, in all cases in equity, thereby becoming the final arbiter and maker of case law governed by American jurisprudence under the rules of the common law. The Supreme Court has no appellate authority over cases in law, also known as jury trials, with the one exception of protecting an individual if an unalienable right of the same is violated. Federal District Court judges, when hearing a case in equity, are governed by American jurisprudence under the rules of common law. In cases in law, judges or magistrates take on an administrative role with no summary judgment powers, whereas the jury, also known as the tribunal of the 12 people, is the final arbiter deciding both the facts and the law, and remedy with the power of nullification and mercy. This is called a court of record, from which there is no appeal, as the Supreme Court had said in the case of Shanecloth versus Bustamante. The decisions of a superior court may only be challenged in a court of appeal. The decisions of an inferior court are subject to collateral attack. In other words, in a superior court, one may sue an inferior court directly, rather than resort to appeal to an appellate court. Decisions of a court of record may not be appealed. It is binding on all other courts. However, no statutory or constitutional court, whether it be an appellate or Supreme Court, can second-guess the judgments of a court of record. The judgments of a court of record, whose jurisdiction is final, is as conclusive on all the world as the judgments of this court would be. It is conclusive on this court as it is on other courts. It puts an end to the inquiry concerning the facts by deciding it. The authority of legislature is limited and defined under Article 1 of the Constitution. The authority of the executive is limited and defined under Article 2 of the Constitution, and the authority of the judiciary is limited and defined under Article 3 of the Constitution. Under our system of government, upon the individuality and intelligence of the citizen, the state does not claim to control him or her except as to his or her conduct to others, leaving him or her the sole judges as to all that affects himself or herself. All laws, rules, and practices which are repugnant to the Constitution are null and void. Every man is independent of all laws except prescribed by nature. He is not bound by any institution formed by his fellow man without his consent. Sovereignty itself is of course not subject to the law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts. And the law is the definition and limitation of power. For the very idea that man may be compelled to hold his life or the means of living or any material right essential to the enjoyment of life at the mere will of another seems to be intolerable in our country, where freedom prevails as being the essence of slavery itself. We, the people, ordained and established the Constitution for the United States of America. We, the people, vested Congress to make law via Article 1, Section 8. We, the people, did not vest Congress with lawmaking powers to control our behavior. We, the people, are above the Constitution and all legislated laws, whereas government authorities are under the Constitution. We, the people, are subject only to the laws of nature's God. All codes, rules, and regulations are for government authorities only, not human creators in accordance with God's laws. All codes, rules, and regulations are unconstitutional and lacking due process. The phrase "at law" is used to point out that thing is to be done according to the course of the common law, is distinguished from a proceeding in equity. Again, all laws, rules, and practices which are repugnant to the Constitution, null and void. Natural law. The only law that applies to we the people are the laws of nature and of nature's God, of which we are entitled. We the people have declared in our founding documents that we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted among men, deriving their just powers from the consent of the governed. Where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. U.S. Titles 18 and U.S. Title 26, when applied upon we the people, are null and void. Congress can make no law or rule to control the behavior of we the people. Nature's law is personified in the following: Jeremiah chapter 31 verse 33 and Hebrews chapter 8 verse 10. But this shall be the covenant that I will make with the house of Israel. After those days, saith the Lord, I will put my law in their inward parts, and write it in their hearts, and will be unto them their God, and they shall be to me my people. And in Romans chapter 2 verses 14 through 15, where we read, For when the Gentiles which have not the law do by nature the things contained in the law, these having not the law are a law unto themselves, which show the work of the law written in their hearts, their conscience also bearing witness, and their thoughts the meanwhile accusing or else excusing one another. Everybody knows when a wrong has been done to another, and by examining our conscience as to what remedy might be necessary to satisfy it, positive law, also known as legislative law, can never take into an account the complexities and differences between each case in courts of justice. Only the human heart, contemplating nature's law, also known as common law, so called because it is law common unto all, can discern justice. As the 12 bear witness to the truth, so a petit jury of 12 bears witness to the truth, and is proper remedy. If a jury is conflicted beyond accord, an accused must be set free, for there is no such thing as a hung jury, and the declaring of a jury hung by one partial state compensated judge who has not had the counseling of 11 other witnesses is a travesty of justice, and places the accused in double jeopardy. This allows the state to continue trial after trial until it gets its desired results. Therefore, a jury must convene and not be given back its liberty until it renders a just decision, which it is its duty to perform. The definition of law is that which is laid down, ordained, or established. It is a rule or method according to which the phenomena or actions coexist or follow each other and must be obeyed or be subject to sanctions or legal consequences. In our republic, common law, equity, and constitution are the law of the land, by which we the people chose to be judged when we assumed the powers of the earth and separate and equal stations which laws of nature and of nature's God entitles us. In the United States, before any court can have authority to hear a case, the court must have both personam and subject matter jurisdiction. Any court, not a court of record, has no authority to proceed without the consent of the persons involved. No judge or legislators can alter that which we the people ordained. To alter is high treason. American courts are vested by the people, the author and the source of law, through constitutions ordained by the people. Therefore, a court must first have constitutional authority over an individual before it can proceed. In criminal cases, a court must have an indictment by an untainted grand jury, in other words, the permission by the people to proceed. Any judge who instructs the petit jury that the said judge decides the law taints the jury and is a pseudo-court under fiction of law. Furthermore, all state laws and constitutions are ultimately governed by the Supremacy Clause of the Constitution for the United States of America, as ordained by we the people, in Article 6, Clause 2, that defines the law of the land, which renders anything in the constitutional laws of any state to the contrary, notwithstanding, in other words, null and void. The United States Supreme Court said no judicial process, whatever form it may assume, can have any lawful authority outside of the limits of the jurisdiction of the court or judge by whom it is issued, and an attempt to enforce it beyond these boundaries is nothing less than lawless violence, and that which the law requires to be done or forborne to a determinate person or the public at large, correlative to a vested and coextensive right in such person or the public, and the breach of which constitutes negligence. Congress was not vested with legislative power to pass civil law, statutes, or criminal law statutes, or any other statute that controls the behavior of the people. There are two common law maxims that govern all criminal cases. Number one, in order for there to be a crime, there must be an injured party. And number two, the state cannot be that injured party. As for the injured party, there is a common law maxim that states, for every injury, there must be a remedy. Therefore, in criminal cases, restitution is more just for the parties than incarceration. (16) American Jurisprudence, 2nd edition, section 114. As to the construction with reference to the common law, an important canon of construction is that the constitutions must be construed to reference to the common law. The common law so permitted the destruction of the abatement of nuisances by summary proceedings. In other words, summary proceedings are not permitted by a judge in a common law court. And it was never supposed that a constitutional provision was intended to interfere with this established principle. Even though there is no common law in the United States in the sense of national customary law as distinguished from the common law of England, adopted in the several states. In interpreting the federal Constitution, recourse may still be had to aid of the common law of England. It has been said that without reference to the common law, the language of the federal Constitution could not be understood. The general misconception is that any statute passed by legislators bearing the appearance of law constitutes the law of the land. The United States Constitution is the supreme law of the land, and any statute to be valid, it must be in agreement with the Constitution. It is impossible for both the Constitution and the law violating it to be valid. One must prevail. This is distinctly stated as follows. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the time of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it had never been passed. Such a statute leaves the question that it purports to settle just as it would be had that the statute not been enacted. Since an unconstitutional law is void, the general principle follows. It imposes no duties. It confers no rights. It creates no office, and it bestows no power or authority on anyone. It affords no protection and justifies no acts performed under it. A void act cannot be legally consistent with a valid one. An unconstitutional law cannot operate to supersede any existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land, it is superseded thereby. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. The author of law. God is the author of common law, which he wrote in the hearts of men, thereby giving we the people both the knowledge of right and wrong, and the unalienable right of we the people to judge each other through tribunals called juries. We the people ordained common law in Amendment 7, and Congress clearly followed suit with the established it through 28 U.S.C. subsection 132. We, the sovereign people, ordained and established the Constitution, which is the law of the land, to be obeyed by all elected, appointed, and hired servants. We, the people, vested Congress with certain lawmaking powers in Article 1, Section 8, among which we gave no legislative powers to write ordinances, regulations, codes, or statutes that would control the behavior of we the people, or apply any set punishment upon we the people. That authority belongs to the people. The very meaning of sovereignty is that the decree of the sovereign makes the law. A consequence of this prerogative is the legal ubiquity of the king. That's nature's God. His majesty in eye of the law is always present in all his courts. Though he cannot personally distribute justice, his judges, which is the jury, the 12 people, are the mirror by which the king's image is reflected. Unalienable rights come from nature's God and are not subject to alienation. The characteristic of those things which cannot be bought or sold or transferred from one person to another, such as certain personal rights, example, liberty. Inalienable, incapable of being alienated, that is, sold and transferred. Rights are defined generally as powers of free action, not subject to legal constraint of others, being unconstrained, having power to follow the dictates of one's own will, not subject to the dominion of another, and not compelled to involuntary servitude. Any statute that violates rights is null and void. Conclusion. Equity courts are for bureaucrats, corporations, and other fictional entities. It's a court not of record, where one judge decides the facts, law, and penalties according to regulations, statutes, codes, or contract under American jurisprudence, whose decisions can be appealed to a higher court. Equity, Black's Law Fourth. Equity is a body of jurisprudence or field of jurisdiction differing in its origin, theory, and methods from the common law. It is a body of rules existing by the side of the original civil law, founded on distinct principles, and claiming incidentally to supersede the civil law in virtue of a superior sanctity inherited in those principles. Whereas law courts are courts of record for the people. It's a court where the tribunal is a jury of 12 people who decide the facts, law, and penalties according to the laws of nature's God, whose decisions cannot be appealed. Courts of record are administered by magistrates who records and enforces the will of the tribunal, in other words, the will of the people. At law, over years. This phrase is used to point out that thing which is to be done according to the course of the common law. It is distinguished from its proceeding in equity. All cases at law, within constitutional guarantee of a trial jury, refers to the common law actions, as distinguished from the causes in equity and certain other proceedings. Decency, security, and liberty alike demands that government officials be subjected to the same rules of conduct that are commanded to the citizens. In a government of laws, existence of the government will be in peril if it fails to observe the law scrupulously. Crime is contagious. If government becomes a lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. And against that pernicious doctrine, this court should resolutely set its face.